Morning, everyone.
Good morning, Commissioner.
Morning. First off, well, I'll wait till everybody at least appears on the screen before I call the case. I see there's a number of individuals here that are appearing. Does anyone notice anyone that they, at least at this point, object to actually being in the hearing at this point?
No.
No.
All right, great. Then let me call the matter of the state of Wisconsin versus Kyle H. Rittenhouse. It's 20 CF 983. May I have the appearances, please?
The state appears by Assistant District Attorneys Thomas Binger and Jason Zaff.
Good morning, Your Honor. Mr. Rittenhouse appears via Zoom from my office. Attorney Mark Richards and Attorney Natalie Wisco. Also present on the call is my investigator. He's in my conference room.
And who is that person?
Steve Spignola.
All right, thank you very much. Others who are appearing, please. Apparently, I go ahead.
Attorney Kimberly Motley is appearing on behalf of Gage Grosskreutz, who's also present, Your Honor. Good afternoon, or good morning.
Good morning. Okay.
This is Anand Swaminathan from Lowy Law Firm, appearing along with my client, John Huber.
All right, thank you. All right, and Detective Antaramian is here, but I assume he's going to be called as a witness at some point, correct?
Yes.
All right. Well, first off, we have a couple of matters here to address prior to the matters calendar for preliminary hearing. We have a couple of matters here that I wish to address first. First off was the issue of the request for admission, pro hac vici admission for two attorneys, I believe Mr. Pierce and Mr. Calderon. Now, I see that Judge Schrader on November 22nd of this year signed the order for admission. I do see the state's brief in opposition to that admissions. And then I see that that was filed today, apparently.
That is correct.
Okay, so I guess how do we reconcile the issue with Judge Schrader had signed the order? Your objection or brief in opposition came a number of days after the order had been signed, unless I missed something.
The timing, Your Honor, was that the defense had filed a request or a motion for those attorneys to be admitted. The day after that, our office had written a letter to the court indicating that we would be objecting to it and asking for a hearing. A few days after that, Judge Schrader went ahead and signed the order admitting them, and then apparently noticed that we'd made an objection and contacted us and indicated that this is something that is normally granted in the course of business, and that if the state had specific concerns, we should bring them to his attention. I have now filed a brief with those concerns. My suggestion, Your Honor, is since today's hearing is going to be handled by Attorney Richards and Attorneys Pierce and Calderon are not here, I don't think there's a need for this to be addressed today. Once the preliminary hearing is over, if the defendant is bound over and this is sent to the circuit court, depending on whether it's Judge Schrader or if there's a substitution, then I think it could be addressed at that time.
All right, thank you, Mr. Richards.
Your Honor, I think the objection is untimely, but I agree with Mr. Binger on just moving this matter forward. We don't need to argue it here. And Judge Schrader, if it's needed, can ultimately decide.
I agree. So that's what we'll do. We'll just set that aside. Obviously, as I indicated, your motion's preserved, or rather, the objection is preserved. You may, if you wish, to take it up further with either Judge Schrader or trial court. All right. Next, then, we have the motion filed by Mr. Richards and a memorandum of law regarding the seeking a dismissal of counts 2 and count 6 of the criminal complaint at this point. That was filed on the 1st. Now, I don't have a response from the state. I would be inclined to grant the state time to submit its own memorandum in opposition, I assume, or if it's in support, you can let me know now, but I doubt if that's the case. Nonetheless, this was only filed 2 days ago. Is the state in receipt of a copy?
Yes.
What's the state's position going forward?
Your Honor, I don't feel a need to file a written response. I think we can argue it now if the court would like to hear argument.
All right, that's fine. Mr. Richards, I've reviewed your motion and your memorandum. So we'll proceed then at this point, if you're all right with that as well.
I think that's the way to go.
All right. Is there anything you'd like to add to your written memorandum of law?
Your Honor, this matter was addressed orally at the first appearance. The court said, file something in writing, you can raise it again, and that's the tact that we took. I think as to count 6, the minor in possession of a firearm, we heard the state's argument at the first appearance. I think the written submission makes it very clear. When Mr. Binger argued it, he was talking about things that are not in the statute. The statutory language states that 948.60 only applies to people armed with a short barrel rifle or shotgun is the first exclusion. I would submit to this court 2 things. 1, there is nothing in the criminal complaint alleging that this is a short-barreled shotgun or rifle. In fact, it says that the gun is a long gun. But more importantly, when one looks at the laundry list of charges the state came up with against my client, it's clear that if in fact this gun was a short-barreled rifle, he would have been charged with the felony count of possession of a short-barreled rifle, contrary to the statute, with additional penalties. The government talked about, well, this is for hunting and things like this. There are 2 other prohibitions that are set forth in the statute. Wisconsin Stat 29.304 only applies to people who are under the age of 16. Consequently, it does not apply to Kyle. The criminal complaint lays or sets forth my client's birth date. He was 17 on August 25th, 2020. As to 29593, that has to do with hunter certification. If an individual is out hunting, and that's what Mr. Binger was hanging his hat on. There is no allegation anywhere that my client was hunting on August 25th, 2020. So it does not meet the requirements of statute 948.63. The statute is clear on its face, must be construed strictly to my client's benefit. Additionally, what the government is trying to seek is an impingement of my client's Second Amendment rights, which is not covered by this statute. It's very specific regarding when it's a misdemeanor, what it applies to, and there's basically 3 prohibitions, none of which are met. The statutory history, which is included in the brief, makes that clear. Count 6 should be dismissed. As to count 2, does the court wish me to do both at the same time or one at a time?
It's probably easier if we do one at a time. That
Okay.
way it keeps it cleaner for the record and also for everyone involved. So, all right, are you done on as far as count 6 then?
I am, Your Honor.
All right, thank you very much, Mr. Richards. Mr. Binger, the state's response, please.
Your Honor, counsel is correct that this court has already heard these arguments and has already rejected an oral motion to dismiss count 6. So we're rehashing ground that we've already covered in this case and has already been decided by Your Honor. First of all, I would note that I don't think there's going to be any dispute that everything that happened on the night of August 25th is transactionally related. So the defense can file a motion to dismiss a count in the complaint today. But if the defendant is bound over for trial, the state will simply file an information containing all transactionally related counts, and we'll let a jury decide. So this is sort of form over substance here, because if the defendant is bound over, we're going to file an information with a charge that the defendant possessed a dangerous weapon as a minor. And so this is sort of moot at that point. However, there is a substantial legal basis for the count 6. And that is, we don't allow teenagers to run around with guns. It's really that simple. The statute is clear. 948.60 says any person under 18 who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor, period. There's no dispute in this case that Kyle Rittenhouse armed himself with an AR-15 on August 25th, 2020 at the age of 17 years old. That's it. It's that simple. Now, if the defense wants to hide behind hunter safety regulations to try and excuse that behavior, then I'll simply quote back what Attorney Richards just said, which is the defendant wasn't hunting. It wasn't hunting season. This wasn't a kid who went up north with his dad and a shotgun and went hunting for deer like last week during hunting season here in Wisconsin. This was a situation in which a teenager went running around the streets of Kenosha after curfew with a very dangerous weapon. And this is exactly why we have this law, because a teenager in this case killed 2 people and shot a third, because teenagers shouldn't be allowed to run around with dangerous weapons because bad things happen. They don't have the judgment, they don't have the experience. We don't trust them with these weapons because of exactly what happened in this case. Now, the defense seems to construe this statute as requiring that we plead their affirmative defense. I don't construe it that way. There is no requirement that we allege that the subsection 3C exception doesn't apply to the defendant. There is no dispute it doesn't apply to him. No one is alleging he's complied with hunter safety regulations or has a certificate or has done the class, or that this was hunting in the traditional sense of the word. This was hunting humans, not deer. This was not up north in a rural area where people are wearing safety orange during gun hunting season in Wisconsin, and they're shooting at deer with their father or their family. That's not what happened here. So I guess, if the court wants us to put that language in there, we can do that, but I don't see that as a requirement. I see this as sort of an affirmative defense that the defense could raise. They're not going to raise it in this case. They've acknowledged it doesn't apply in this case. And that would be the only exception that would allow the defendant to run around with this AR-15, and it doesn't apply here. So I think under those circumstances, as the court has already ruled at the initial appearance, count 6 is an appropriate count. It should be maintained at the beginning of the preliminary hearing, and we will certainly be filing an information after bind over to reintroduce that count no matter what. Thank you.
Your Honor, just briefly in
Go
response.
ahead, Mr. Richards.
Where I went to law school, I was taught one was supposed to read the whole statute. You don't stop after the first sentence like Mr. Binger has. And whether it's transactionally related or not transactionally related, if it's dismissed here, they can't put it on the information. If they do, we'll file the next motion again under the applicable case law. But Mr. Binger seems to be arguing that Wisconsin statute that my client is charged under only applies to people up north or things like that. It's Wisconsin statute. It applies to the whole state. Those aren't affirmative defenses. They're saying it doesn't apply. We're not arguing that he was hunter safety. That's not what it says. He's not hunting, so that subsection doesn't apply. He's over 16. That subsection doesn't apply. And in fact, he is not possessing a short-barreled rifle. Consequently, he is not to be charged with this offense. Thank you.
All right, thank you very much. Well, courts reviewed 948.60, the statute in question here, possession of a dangerous weapon by a person under 18, which is the basis of count 6, and specifically sub 2, sub A set forth. Now here, I'm looking at what a statute means versus what the legislature's intent was. I'm going to look at what the statute, the plain language of the statute, as Mr. Richards pointed out and Mr. Binger alluded to as well. Now, when I look at that statute, it talks about, it defines what a dangerous weapon is: any firearm loaded or unloaded, any electronic or electric weapon as defined further in the statute, 941.295 sub 1C sub A. And then it goes on to list other additional items which are defined as being weapons. But specifically dangerous weapon, which is quoted, means any firearm loaded or unloaded. Clearly in the case at bar here, it is a loaded firearm. It was possessed by someone 17 years old, which is it's uncontroverted that this defendant was 17 years old and had not attained the age of 18 on the night in question, August 25th of 2020. And if you look at the plain language here, and I understand reading the whole statute, which I have done as well, but I do see here that I think it's a bit of a red herring to discuss barrel length or to discuss whether or not there are any hunting regulations that should be in play here. I believe that clouds the issue, and I believe the issue at this point, for purposes of whether or not to grant the motion or not grant the motion and move this matter forward to preliminary hearing, for purposes here, I'm going to deny that motion. And again, I believe it perhaps is a trial issue. Mr. Richards argues it's not an affirmative defense, as Mr. Binger believes it to be. That's for another court or a jury to decide in the future. But for purposes of today, for these reasons, I'm going to deny your motion, Mr. Richards, to dismiss count 6. You may obviously take the matter up further or address that issue at trial, obviously. Now, let's discuss then the second part of your motion, I believe is count 2, which is the first degree recklessly endangering safety, use of a dangerous weapon regarding an individual with the name of Richard McGinnis. So I'll give you the first, if you will, again, addressing of the issue, Mr. Richards.
Your Honor, my brief sets forth the jury instruction in Wisconsin Jury Instruction 1345. Defendant endangered the safety of another human being. The defendant endangered by criminally reckless conduct, and the circumstances of the conduct showed utter disregard for human life. There's nothing in the criminal complaint that says Mr. McGinnis was in the line of fire. There's nothing in the criminal complaint that says he feared for his safety. There's nothing in the complaint that my client recklessly, intentionally, or otherwise pointed the gun at Mr. McGinnis. I believe based upon that, the count 2, as it applies to Mr. McGinnis, should be dismissed.
Thank you very much, Mr. Binger.
The complaint does explicitly say that Mr. Guinness was in the line of fire. I'll read the relevant portion, which I believe is at the top of page 4 of the complaint. I'll actually begin at the bottom of page 3 and put it in context. I'm going to start by reading the final paragraph on the bottom of page 3. It begins, McGinnis described, and it's a paragraph that continues on to the top of the next page. The paragraph states, McGinnis described the point where the defendant had reached the car. McGinnis described that the defendant had the gun in a low, ready position, meaning that he had the gun raised but pointed downward. The butt of the gun would have been at an angle downwards from the shoulder. McGinnis stated that the defendant brought the gun up. McGinnis stated that he stepped back and he thinks the defendant, this is at the top of page 4, he thinks the defendant fired 3 rounds in rapid succession. McGinnis said that when the first round went off, he thought it hit the pavement. McGinnis felt something on his leg, and his first thought was wondering whether he had gotten shot. McGinnis was behind and slightly to the right of Rosenbaum in the line of fire when the defendant shot. That ends that paragraph. As the paragraph indicates, which is in the complaint, Mr. McGinnis was in the line of fire, felt that he had been shot, and was in close proximity to someone who was shot and killed by the defendant. I believe that that satisfies the statutory requirements, and the motion to dismiss count 2 should be denied. Thank you.
Thank you,
Your
Mr.
Honor, just
Richards.
briefly, he says he was to the side. He doesn't say what touched his leg, what he might have felt touching his leg. It doesn't show that he was endangered. It's a conclusory allegation that isn't based upon the statement. It's not what Mr. McGinnis said. It's what the state says in a conclusion. Thank you.
Thank you very much. Well, I've read the complaint as well, obviously, and again, a number of times. And the issue comes down to what's a reasonable inference or not. In this case, when you discharge, or it's alleged that this defendant discharged a firearm in a crowded urban environment, one could argue that's inherently dangerous nonetheless. Issues whether or not that was in self-defense or otherwise are for trial, obviously. With respect to the issue of whether or not, in this case, Mr. McGinnis was endangered or recklessly endangered, that's, again, an issue for trial. When you have in the complaint sets forth reasonable inferences that this defendant discharged a weapon that Mr. McGinnis thought it hit the pavement. Okay, well, as most people know, when a bullet ricochets, you never know, for the most part, where that bullet's going to ricochet to or what trajectory the bullet takes. I don't know, as I sit here today, whether or not what Mr. McGinnis indicated, according to the complaint, they're feeling something on his leg. I don't know what that was. That's a trial issue, I believe. And again, a reasonable inference here that Mr. McGinnis has set forth, it says in the line of fire. That is definitely probably a trial issue in terms of whether or not Mr. McGinnis was had his safety endangered recklessly by this defendant with respect to the alleged discharge of the weapon. So for all of those reasons, again, there are some conclusory statements on both sides here. Those are issues for trial. This court is going to deny your motion for count 2 as well, Mr. Richards, for the reasons I've just stated. And I believe, again, these are reasonable inferences, which at this juncture, we all know are decided in favor of the state. So we're going to move forward now. I've made the ruling. You may take, obviously, that issue up further as well, or leave it for trial. I'll leave it up to you, Mr. Richards, but there's my decision. So now I want to make sure, have we dealt with all of the issues that I need to deal with prior to conducting the preliminary hearing? Mr. Richards,
I believe so, Your Honor.
Okay, all right, thank you. Mr. Richards?
I believe so.
All right, great. So now we're here for a preliminary hearing as well. Now, I assume the hearing is to be conducted. Is that correct, Mr. Richards?
Yes,
All right. I assume you tell me, Mr. Binger, there's been no offer tendered at this point. Is that correct?
That is correct.
All right. Is the state prepared to move to hearing today?
Yes, we are.
How many witnesses does the state anticipate?
One,
All right. Mr. Richards, is the defense prepared to move to hearing today?
it is.
And how many witnesses do you anticipate for the defense?
It depends on what happens with the government's witness. If that witness is able to answer the questions, I won't need a witness.
All right. Well, we'll decide that following, I guess, the witness for the state. All right, then, Mr. Binger, you may call your first witness.
the state calls Kenosha Police Detective Benjamin Antaramian.
All right, Detective Antaramian, would you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you?
I do.
Great, babe. Put your hand down, please. Would you please state your full name and spell your last name for the record, please?
Detective Benjamin Antaramian. Last name is spelled A-N-T as in Tom, A-R-A-M as in Mary, I-A-N as in Nora.
Thank you very much. Mr. Binger, your witness.
Sir, how are you currently employed?
I'm a detective with the City of Kenosha Police Department.
How long have you been with the Kenosha Police Department?
Just shy of 10 years,
How long have you been a detective?
2.5.
And are you currently assigned to the investigation with regard to the incidents which occurred on August 25th, 2020 with regard to the defendant Kyle Rittenhouse?
Yes, I am.
Do you see that individual here on this Zoom broadcast?
All right, let me stop for a second here. I'd like to address the issue. There you go. And I guess we're at a bit of a distance, Mr. Richards, from
Your Honor, for the purposes of this hearing, I will stipulate that my client is seated wearing a blue shirt. He just pulled his mask down. He is Kyle Rittenhouse.
All right, thank you. Then the record will reflect that pursuant to the stipulation, the defendant in this case has been identified. All right, you may proceed then, Mr. Binger.
Detective Antaramian, have you reviewed the criminal complaint in this matter?
I have.
Okay. And with regard to those incidents which occurred on August 25th, 2020, can you describe what happened that evening with regard to the defendant?
Yeah, there was a call at 6226 Sheridan Road, which is a car source business, where shots were fired. Investigation later determined that Joseph Rosenbaum was shot in that parking lot and later determined to be deceased. Then Kyle Rittenhouse was the shooter in that incident. He then fled that scene northbound on Sheridan Road in the city and county of Kenosha.
And just to be clear, the address you've described of 6226 Sheridan Road and all of the other addresses with regard to this incident, are those all in the city and county of Kenosha, state of Wisconsin?
Correct.
And can you describe what happened after the defendant left the scene of the Rosenbaum shooting?
As he was running northbound, there was a crowd chasing after him. He ends up stumbling in the roadway after being struck in the head. When he's on the ground, a subject attempts to kick him in the head. He then fired 2 rounds in the air towards that subject, missing. Another subject approached him with a skateboard, and another shot was fired. That subject is identified as Anthony Huber. That gunshot subsequently killed him. Excuse me. Another subject approached Kyle, identified as Gage Grosskreutz. They had kind of a moment at which point Kyle fired 1 time, striking him in the right bicep. Kyle's then able to get up and get away from that scene.
You described 3 individuals who approached the defendant. The first one you indicated had attempted to kick the defendant. Is that correct?
Correct.
Was that individual ever identified?
As of now, no.
Now, you indicated that the defendant fired 2 shots in the air at about the same time as that first individual approached him. Can you describe the location of those shots vis-a-vis the location of that individual?
They were in close proximity to kind of his chin area as he's going over Kyle. Those 2 rounds pass, I'm assuming, relatively close to the front of his face, missing just barely.
How are you able to know this information? Were you personally there?
No, I've reviewed multiple videos of this incident.
Is it fair to say that much of what you've described here was captured on video by numerous sources that evening?
Correct.
And with regard to that first individual, did the defendant shoot at that individual?
You're referring to the one who attempted to kick him?
Yes.
Yeah, at the individual, absolutely.
Was that individual struck?
I don't believe so. We've never identified him.
And you said there was a second individual subsequently identified as Anthony Huber who approached the defendant. Was that captured on video?
Correct.
And what does that video show that Mr. Huber did with regard to the defendant?
At that point, the defendant's on the ground. Mr. Huber approaches him with a skateboard in his arm or in his hand. He's sort of directing it kind of towards his shoulder neck area, and it appears he's trying to reach for the rifle that the defendant is possessing at that time. It's hard to tell if there's actual contact, but then a shot is fired.
And when you say a shot is fired, who fired that shot?
The defendant.
And did that shot strike and kill Mr. Huber?
Yes, it did.
What sort of weapon was the defendant using?
It's commonly referred to as an AR-15. It's an AR-style platform rifle chambered in .223.
You indicated that after the defendant shot and killed Mr. Huber, Mr. Grosskreutz approached him. Is that correct?
Correct.
And after that, then the defendant then shot Mr. Grosskreutz in the arm. Is that correct?
Correct.
I have no further questions, Your Honor.
All right, thank you very much. Mr. Richards, you may cross-examine the detective.
I'm going to go to split screen and have some exhibits.
All right, as long as they're, have they been, you need to make those available, I guess, to Mr. Binger. Have you seen these exhibits?
No, I have not.
All right, well, what type of exhibits do you have before?
Photographs from the videos and still photographs taken that evening.
All right, and I guess what I'm going to ask, you're going to first show those videos or those, excuse me, the photographs to this detective to authenticate those? Is that what you're going to
Yes.
do or attempt to do?
Yes.
Mr. Binger?
That's fine, Your Honor.
All right, that's fine. You may proceed then.
They have to enable it,
Your Honor, I believe you have to enable the split screen,
the screen sharing.
screen sharing.
Well, if you leave it to me, Mr. Richards, good luck to all of us. But let's see if there's more talented people, let's put it that way.
I have my assistant doing that for me, so.
Yeah, leave it to me. We're still using, I'm using crayons, okay? So let's,
Can the witness see exhibit 1?
Yeah, just loaded.
Okay, sir, you've testified that you're an investigator and have watched multiple videos and looked at still photographs in this matter?
Correct.
And showing you exhibit 1, the individual centered with the bald head, who is that?
Joseph Rosenbaum.
And the individual who is standing behind him wearing a blue cap, a gray hoodie, and a kind of purplish mask with glasses, who is that?
Anthony Huber.
And Mr. Rosenbaum, does he have anything on his head at this time?
No.
I didn't hear that, sir.
No, he does not have anything on his head.
And what color is his shirt?
Pale red.
Okay. Showing you what's been marked as exhibit 2, and I can submit all of these photographs digitally after the hearing. This is a still shot of the events of 8/25/2020 at the Car Source lot at what I'll refer to as 63rd and Sheridan Road. Do you see an individual in full stride running?
Yeah, I guess kind of off left center, if you will.
Correct.
Yep.
Who is that based upon your investigation?
That is also Joseph Rosenbaum, as seen earlier in the pictures.
And who is he running towards, if you know?
That'd be Kyle Rittenhouse running from him.
Okay. And this is a still shot of a video you've watched, correct?
Correct.
And the video begins with an individual by the name of Mr. Zeminski telling Rosenbaum to get or kill my client, Mr. Rittenhouse, correct?
I'm going to object to the relevance, Your Honor.
Mr. Richards?
It goes to my client why he's running and being chased by somebody who's going to be an armed robber.
Well, that's a conclusion, but I'm gonna allow, give a little latitude here, but we'll take this on a question by question basis, though, okay? Mr.
Understood.
Richards?
You saw
Can you
that
repeat the
video?
question, sir?
You saw this video, and in the video, it starts with Mr. Zeminski saying to Rosenbaum, get him or kill him, correct?
Excuse me. I have not heard that line, and I definitely could not say with certainty that I heard Mr. Zeminski saying that.
Okay, did you hear Mr. Zeminski give Mr. Rosenbaum some sort of direction before he began chasing him?
Objection, relevance.
I'm asking if he heard it, then we'll know whether it's relevant or not if he did.
I'll allow it, just the answer at this point.
No, I have not.
Okay. Showing you what's been marked, we'll strike that. This individual in the far right with his arm raised up, do you know who that is?
The one that your mouse just pointed to?
Yes.
Yeah, that's Mr. Zeminski.
Okay, my client did not fire the first shot at Car Source on August 25th of 2020, correct?
Objection, relevance.
What's the relevance of that then, Mr. Richards?
It goes to my client why he's running and why Mr. Zeminski's shooting at him.
Well, it might, but not with the question that you asked. So I'm going to sustain the objection in terms of who fired, or that whether or not your client fired his shot that time.
Mr. Zeminski fired his gun while Mr. Rosenbaum was chasing my client, correct?
Objection, relevance.
Mr. Richards?
It's relevant. It goes to the events in question of how it was Mr. Rosenbaum became shot.
Your Honor, we're getting into what I know the defense wants to do today, which is make this a self-defense case. And as the court has already indicated, that's an issue for trial. What happened before this incident, what happened with regard to Mr. Zeminski is beyond the scope of this prelim. It does not go to the probable cause as to whether or not the defendant committed a felony. And I object to the relevance of this.
It does.
But relevance is a low burden. I'll tell you what, I'll overrule on this question, but again, I'm going to keep a tight rein on it, Mr. Richards, as you understand.
Understood.
All right, go ahead. Detective, you can answer this question if you remember it. Otherwise, we'll have to have the question given again.
You could repeat it, please.
My client in Exhibit 2 is running from Mr. Rosenbaum when a shot is fired by Mr. Zeminski, correct?
Correct.
Showing you what's been marked as Exhibit 3. That's a picture of Mr. Rosenbaum after he's been shot and he's wearing a mask, correct?
Correct.
It's a crime in Wisconsin to commit a crime while masked, correct?
Objection, relevance.
Wait, I hear somebody in the background. Please refrain from saying something if there's somebody commenting in the background or making noises, please. Thank you.
Your Honor, I objected to relevance of this question.
Yeah, I that one, go ahead, I'll let you respond, Mr. Richards, but
It goes to the events in question. The state is trying to put forth a one-sided, stilted view of what happened, protecting someone who doesn't deserve protection of the state. He's a masked robber.
okay, this is preliminary hearing. I'm going to sustain the objection, and for purposes of preliminary hearing, that's outside the scope. It's not relevant for these purposes. Mr. Richards.
Mr. Rosenbaum is not wearing a shirt in Exhibit 3, correct?
Not wearing it traditionally.
He's wearing it around his face, correct?
Correct.
Showing you what's been marked as Exhibit 4. The bearded individual in the upper right-hand corner, do you recognize him?
Objection, relevance.
All right, what's the relevance of this now, Mr.
Mr.
Richards?
Zeminski holding a firearm, the individual who shot first at Kyle. You can see the
Well,
firearm
that-
clearly.
Okay, but that's at this juncture, your second part of your statement or your comment, shot first, is outside the scope of this examination. For that purpose, I'm going to sustain that objection.
As to Exhibit 4, do you recognize the bearded individual?
Objections, the same question that I've just objected to. It's not relevant.
I'm not asking about the gun. I'm trying to identify the individual for the purposes of this hearing.
Your Honor, we're talking about individuals that don't have anything to do with this. They are outside the scope of this preliminary hearing. There were literally hundreds of individuals there that evening, and we're not going to expand this preliminary hearing into identifying a cast of characters that the defense thinks is relevant to their self-defense argument. That is well beyond the scope of probable cause as to whether or not the defendant committed a felony.
Mr. Richards, as an offer of proof, until I rule, with respect to these individuals that how many individuals are you going to, or you anticipate to name, and who is this individual allegedly at this point?
It is Mr. Zeminski, the individual who is charged with firing the first shot in 20 CM 1219, who this officer detective, I apologize, who this officer testified is depicted in Exhibit 3. I'm identifying him this is a clear shot of that individual.
All right, I'll allow it for that limited purpose. All right, go ahead, detective, if you can answer the question.
The individual in the upper right-hand corner is, in fact, Joshua Zeminski.
The bearded individual, correct? Just to clarify.
Oh, correct.
Thank you. Exhibit 5. The individual on the far right of Exhibit 5 is Mr. Huber wearing the hoodie with 2 backpack straps, correct?
Correct.
Exhibit 6. This is a still photograph of the incident occurring at 61st and approximately 61st and Sheridan Road, correct?
Mr. Richards, are you testifying, or are you going to ask this witness to identify something? I understand you're trying to move the matter a bit, but shouldn't you
It's
ask
cross-examination.
this witness if he knows what that image is? All right.
Your Honor,
But
I get to
you're not asking a
cross-examine.
question, you're testifying. Yes, you do, and I'm giving you that right.
Sir.
You don't have a right to make us to ask the, all right? Go ahead. Put the question in the
recognize
proper form,
Exhibit
Mr. Richards, and you allow it.
Okay. Sir, do you recognize Exhibit 6?
Yes, I do.
Okay, where that is in the area of 61st and Sheridan Road in the county of Kenosha?
Yes, sir.
And this is a still photograph from a video you reviewed?
Correct.
My client is on the ground, correct?
Yes, sir.
In the center of the picture, for lack of a better location?
Yeah.
And an individual runs up on my client, correct?
Correct.
You've watched the video. Does my client shoot that individual when he backs off?
Say when he backs off, I'm sorry.
My client does not shoot that individual or shoot at that individual, correct?
Correct.
The individual in the white pants running towards my client, that is the individual who jumps up and kicks my client in the head, correct?
It appears he attempts to. I don't think contact is made.
Showing you what's been marked as Exhibit 7. You've seen this photograph?
Correct.
And that is an unidentified individual who I will refer as to jump kick man kicking my client, correct?
Correct.
You can see my client being knocked backwards in this photograph, correct?
Correct.
So contact was made, correct?
Yes, sir.
And as Kyle is being knocked backwards, you see an individual with a skateboard approaching my client, correct?
Yes, sir.
And based upon the clothing and the straps, who is that?
That's Anthony Huber, sir.
Okay. And he has just retrieved his skateboard from swinging at it, trying to hit Kyle earlier, correct?
Correct.
Next exhibit. You testified on direct examination that Mr. Huber tries to hit my client in the shoulder neck area, correct?
Correct.
He hits him in the back of the head. Is that a fair statement based upon Exhibit 8?
The picture's a freeze frame. It's hard to see the actual motion of it. I mean, contact's definitely near the back of the head, but I couldn't say there's direct contact.
On the early morning hours of August 26th, you took a photograph of a large bump on the back of my client's head where he had turned himself in at the Antioch Police Department, correct?
I did not take that photograph. My partner did.
Okay, you've seen that photograph, correct?
Correct.
And that photograph was on my client's head, not his shoulder or neck. Fair statement?
Correct.
The individual, which you see his hind end, that is the person who's unidentified, who I would refer to as jump kick man, hitting the ground, correct?
Yes, sir.
Showing you what's been marked as exhibit number 9. This is a photograph of Mr. Huber with his hand on Kyle Rittenhouse's gun, correct?
Yes, sir.
And do you know of any reasonable purpose why an individual can attempt to disarm somebody?
There can be, yes.
If the person has committed a crime?
That'd be fair to say.
Okay. Exhibit 9 shows the individual jump kick man running away from the scene, correct?
Yes.
He's never identified himself to law enforcement or complained of any injury or any endangerment, correct?
Correct.
Showing you what's been marked as exhibit 10. This is Mr. Huber holding his chest, dropping his skateboard on the ground in the fore of the image, correct?
Yes, sir.
Mr. Grosowitz is surrendering to my client, putting his hands up, correct?
His hands are up, correct.
Okay, and in his right hand, you can see the butt of a 9mm handgun, correct?
I couldn't tell you caliber, sir, but there's a firearm in his hand.
Okay, and through your investigation later on, you know that it's a 9mm handgun, correct?
I believe it's a .40 caliber, sir, but I'd have to
Okay.
consult my reports.
And you would know more than me. Showing you what's been marked as exhibit 11. It's Mr. Grosowitz running up on my client after he had his hands in the air. A still photograph of the video, correct?
Yes, sir.
And once he put his hands in the air, eventually he dropped his hands and went closer, according to the video, correct?
Yes, sir.
Showing you what's been marked as exhibit 12. Mr. Grosowitz in his right hand, you can clearly see a firearm, correct?
Yes, sir.
He's pointing it at my client, correct?
It appears so on the picture, sir.
Okay, and my client fires one shot and you can see that Mr. Groskowitz's arm is hit, correct?
Yes, sir.
That's the last individual my client shot on August 25th, 2020.
Yes, sir.
And there are individuals in this video at approximately 9 o'clock, 12 o'clock, and 3 o'clock, which are approaching my client, and he points the firearm at them but does not shoot, correct?
Yes, sir.
And he gets up and he goes to turn himself into law enforcement with his hands up, correct?
Correct.
And he's told to get out of the street or he'll be pepper sprayed, correct?
Objection, relevance.
Do you want this picture?
I'll sustain that.
He goes towards law enforcement with his hands up, not holding his firearm in his arms, correct?
Correct.
He approaches a police car and gets onto the sidewalk.
I'm gonna object to the relevance, Your Honor.
Mr. Richards,
It's relevant.
I'm going to sustain the objection.
The you did not go out and arrest my client. He had turned himself into the Antioch Police Department, correct?
Objection, relevance.
Again, for purposes of preliminary hearing, I'm going to sustain the objection.
All of the events from the shooting of Mr. Rosenbaum to the shooting of Gage Groskowitz took place in a time frame on August 25th of less than 5 minutes, correct?
Correct.
In your investigation and looking at all the hours of videos, did you ever see Kyle act inappropriate towards somebody who was not threatening him with a firearm?
Objection, relevance.
Again, I'm going to sustain.
Relevant.
I
Government
am
just
going to
doesn't want to
sustain
hear the
that.
truth.
Mr. Richards, here's the key. You have an opportunity at trial, but we're here at preliminary hearing. I understand perhaps you're frustrated, but perhaps we continue the examination.
Okay.
They can still see the exhibit.
You can turn it down. Just checking my notes.
Okay.
You've been contacted by Mr. McGinnis's lawyer telling you that he does not agree with the statements which are contained in the criminal complaint regarding what happened on August 25th, correct, Detective?
Objection, relevance.
I will sustain that as well for purposes of preliminary hearing.
In the video, before my client is knocked to the ground by the strike to the head, you hear numerous individuals yelling, "Kill him, get him, cranium him," correct?
Correct.
Nothing further.
All right, thank you very much, Mr. Richards. Mr. Binger, any redirect for this witness?
No, Your Honor.
All right, thank you, Detective. That'll conclude your testimony. Thank you. State has no further witnesses, is that correct?
That is correct.
State rests.
Correct.
All right, thank you. Mr. Richards, do you have any witnesses at this point?
Your Honor, I don't need to call any. Thank you.
All right, thank you. Then the defense rests, correct?
Yes.
All right, thank you very much. All right.
I would move in
Mr.
the,
Binger. Oh,
Your Honor, I'm sorry to interrupt.
okay, go ahead.
I would move in the exhibits that were
That's right.
testified. And I can
Well,
send
all
a
right, let's.
digital,
Okay, I'm sorry. I didn't mean to interrupt you. Go ahead.
I apologize. And I can send a digital copy, or I can actually have the hard copies of the photographs, whatever the court and the record would prefer.
All right, we'll take that up in a minute. Mr. Binger, I know there was some issues with the, I believe it was Exhibit 3, the photograph, but aside, as to Mr. Richards moving all exhibits in, any objections to that?
No, Your Honor.
All right, then all exhibits shall be received. And now as far as, I assume if you want to upload those, that might be easier to allow all parties to receive those rather than physically having to bring those down to the courthouse. That's all right, Mr. Binger?
That's fine.
That's fine.
And, all right, good. Then that, there you go. That can be what you do. All right, then, Mr. Binger, as to state's position on bind over.
Your Honor, I believe the evidence in this preliminary hearing has established probable cause that the defendant committed a felony on August 25th, 2020. The evidence indicates that the defendant shot and killed 2 individuals and shot and wounded another, which forms the basis for any number of felonies under our laws. All this court needs to find is that a felony was committed and probably committed by the defendant, and I believe this evidence supports that. With regard to the defense claim as to self-defense, that does not defeat probable cause at this stage of the proceeding. That would be an issue for trial. So I would ask that the court bind the defendant over. Thank you.
Thank you, Mr. Richards.
Your Honor, we would object to bind over, maintaining all objections to the pretrial rulings and the bind over. The government can go off on their chaotic quest, but the evidence is clear. Thank you.
All right, thank you very much. First off, the court does find that hearsay testimony is reliable for purpose of determining whether probable cause exists and is allowable pursuant to section 970.038 of the Wisconsin statutes, and further allowable to the case of State v. O'Brien 354 with second 753 2014 case. In addition, all reasonable conflicting inferences at this juncture are resolved in favor of the state. Therefore, based upon the testimony presented today by the detective, I do find the state has demonstrated probable cause that in this case, felonies were committed relating to the counts in the complaint. I bind over as such that probable cause further exists that this defendant committed those felonies, including count 1 and the other felonies here in this file or in the criminal complaint. Therefore, as I do find that probable cause exists that the defendant committed those felonies, the defendant in this case is bound over before the Kenosha County Circuit Court, before the Honorable Bruce E. Schrader at this time. Now, Mr. Binger, barring any, will there be any, I assume, Mr. Richards, you would have let me know by now, but is there any substitution requested at this point?
No.
Okay, then will you be filing? I do wish to move to arraignment if there is an information which has been filed, or will that be required to come back here at a different date?
Your Honor, I would request an arraignment date, Your Honor. Thank you.
All right,
We'll
Mr.
be
Richards,
filing an arraignment
state has up
within 30
30.
days.
Right, state has 30 days. We're going to calendar that though, just so the parties are aware, back here before this court, and then we'll set it on for arraignment. Bond will continue as previously set. And thank you, everyone.
Thank you.
Arraignment December 29th at 1 o'clock.
The last 2 weeks, I'm kind of gone. I'm not kind of gone. I am
I was just going to say, what does kind of mean? Does that mean like your left leg is here and your right leg somewhere?
gone. I'm going to leave one of my personalities in the office.
Hey. I enjoyed them all, by the way. Well, here's the deal. What I worry about is that do we fall outside the 30 days?
It just has to be filed within
Right.
30 days. So the first week in January would be fine.
Is that okay? All right, then there's not going to, I didn't want to have it come back and then I'm having to deal with that issue. So that's fine.
We'll make sure the information gets filed within 30 days, Your Honor. Thank you.
Great. Thank you.
January 5th at 1 o'clock.
That's fine with me.
That works for the state.
All right, great. Thank you, everyone. Take care.
Have
Thank
a
you.
good holiday.
Thank you.
Thanks a lot. Bye-bye.